About how U.S. attorneys function this afternoon. You worked for Preet Bharara in the Southern District of New York. If you come into his office and put a case file, you're already ahead of me here, put a case file in front of him, is he going to be curious and or launch a subset of research into your underlying facts, conclusions, and testimony before he charges an individual with the full weight and power of the federal government?
So I've been thinking about this too, and not just about Preet, because I worked for many different U.S. attorneys, Republicans, appointed by Republicans and Democrats, going back to Mary Jo White. And here's the thing: if an important case, which this is, the most important one could say, if I come in and I make a recommendation that we should proceed a certain way, if the U.S. attorney agrees with me, in all likelihood, they will read what I have summarized for them in the form of a prosecution memo. That's what we've been calling a pros memo. They may look at some individual pieces of evidence. But if they are going to go against what I have recommended, or if I have not made a decision, if I have said for whatever reason it's too hard, or there's this legal impediment, I cannot come to a clear conclusion, or I will not, they are not going to make a decision without looking at the evidence. I mean, that is just, it's disrespectful. It's, I won't use the word lawless because it's not about a law, but it is just, it's reckless. You don't take what career prosecutors have done, and Bob Mueller is of course a career prosecutor. He's parsing words there. And his team have done for almost 2 years and say, no, we're going to do this, even though we're going to do Y, even though you did X, and we're not going to look at the evidence. It just makes no sense. You don't have to be a lawyer or a prosecutor to know that.
And just